Hi friends, good morning. I am Rudran. Today we will talk about the brief outline of international criminal law. The criminal law, international criminal law, actually it's a distinct branch of international law which deals with the individual criminal responsibility of international crimes. See, all aware international law generally deals the relationship between the state or multiple state or nations, whereas international criminal law deals specifically the individual criminal liability those who commit international crimes. We will see some important definitions of the leading scholar. Uh, Antonio Cases, who's an Italian jurist, is a founder of modern international criminal law. Antonio Cases defined international criminal law as a body of rules, proscribe, prohibits certain conduct, and those who engage in the conduct are criminally liable and punishable through enforcement mechanism. Where Antonio Casio highlighted prohibition of certain conduct, individual criminal responsibility, and highlighted the punishment for those who commit international crimes. Further, M. Cherif Basioni, considered as a father of international criminal law, he has defined international criminal law is a body of international law imposes individual criminal liability those who commits international crimes. Here, Cherif Basioni also specified individual criminal responsibility and followed by those who commits international crimes are punished through enforcement mechanism. So now we have seen very important definitions of the leading scholars where international criminal law specifies about individual criminal responsibility and those who commits international crimes are punishable under enforcement mechanism. Now we will see the nature of international crime. See, generally crimes, these crimes are not merely a crime against individual or state or any victim. These crimes are exceptionally grave in nature, which shocks the conscience of humanity. This international criminal law, which is beyond brutality, beyond heinous, and which is the conduct is so inhuman and very cruel in nature actually. Uh, so in general, international crimes are exceptionally grave in nature, and it outrages the moral values of international community. So this is considered as these international crimes are considered to be a it is actually against entire humanity. The concept of hostis humani generis principle has been existed. This concept actually existed the first the recognition of international crimes called piracy. The pirates are considered as hostis humanis generis. They are the enemies of all mankind. So, the international crimes are so exceptionally grave in nature actually. Example, during World War time, Adolf Eichmann was deported, transported approximately 6 million Jews to the poisonous concentrated chamber and killed. Uh, the term called Holocaust, the modern term as a genocide. And it is not only Holocaust or it is a mass killing, mass murders, mass extermination, or mass killing, mass shooting of war criminals, or mass killing of prisoners of war, or the gross violation of humanitarian law. So these are the crimes are considered to be international crime, which is grave in nature actually. And these international crimes attracts universal jurisdiction. It means any state can prosecute and punish the person who commits international crime. See, so we have discussed the hostis humani generis. This concept actually transformed into the modern international criminal law of universal jurisdiction. So any state can prosecute the person who has committed. There is no boundary limitation on the territorial jurisdiction for the prosecution of the person who has committed the international crime. And see, and this international crime means it is actually gross violation of just cogent principle. It is actually peremptory norms, which is established, among the states. Every state has a duty and responsibility with the international community or the state. So, like example, the prohibition of genocide, prohibition of torture, prohibition of slavery, or prohibition of slavery trade, or trafficking of human. These all generally prohibited as per the just cogent principle, which becomes some obligation. That is ergonomous obligation where state has to follow. So this just cogent is actually a non-degradable principle. It cannot be changed, altered at any point of time. And one more thing, those who commit international crimes, they cannot claim any superior order. So they cannot say that the superior order has been followed for the commission of the international crimes. And international crimes cannot claim immunity as being as a state head. So even though they are a state head or IS of officials or the military commander, they cannot claim immunity that's stated. And another thing, they cannot, those who commit international crime, they cannot claim the statutory order. They cannot say that it is a statutory order that international crimes has been committed. And it attracts universal jurisdiction where anybody can be prosecuted under the international crimes. It can be prosecuted uh, under the international criminal court. So now we'll try to understand. And one more thing of international crime actually is it focuses on impunity. It means nobody can be escaped after committing the international crime. So this all about the basic, the important nature of international crimes. And we will try to understand the sources of international criminal law. The sources, the important sources of international criminal law, the concept of international criminal law exists since from the ancient period actually. So we'll see one by one. The principle like nullam crimen sine lege or nullam pona sine lege. The concept actually, the crime and punishment can be imposed only if it is defined in the law. Nullam crimen sine lege, actually there is no crime unless it is defined in the law. And at the same way, nullam pona sine lege is there is no punishment unless defined in the law. So not only these very the pillars of the general principles of law, it is also that like fair trial and the principle of rule of law, the principle of equality. These things also be followed under the general principles of development of criminal law. And further, the customary principles of law, which also established, so which is actually the consistent practice, the unwritten rules which is practiced as a customary law, which is being adopted as a universal jurisdiction, like piracy, which is considered as an international crime, which is followed as a customary practice. And even humanitarian law, there are some laws which prohibits certain conduct, like the killing of prisoners of war, like protection of victims during the war, or protection of civilians during the war. There are some principles which exist as a customary law, where it becomes a precursor in codification of uh, like Geneva Convention or Hague Convention. These are principles evolved from the customary principles of law. Now we'll go to the next thing is the development of international criminal law from the agreements, treaties, and conventions. Actually, see during the World War One, the William Kaiser was tried for the prosecution who was committed international crime, where he has killed approximately 30 millions during World War One. The Treaty of Versailles, Article 227 of Treaty of Versailles 1919 actually proposed to prosecute William Kaiser, but unfortunately William Kaiser has escaped to Netherlands. The failure in extradition of William Kaiser, which failed actually for the prosecution. Further, during World War Two, the mass atrocities of Nazi European Axis power actually, made to development of London Agreement, the 8th August 1945, the London Agreement made by the Allied powers, where Allied powers not only want to, just politically they want to prosecute the war criminals, the legally also they want to prosecute the war criminals of Nazis. They have prosecuted, they have created Nuremberg Charter and Nuremberg Trial and prosecuted the Nazi criminals. It is one of the important landmark in the development of the international criminal law. And followed by the Geneva Convention 1949 and Genocide Convention 1948, which also becomes the pillar in development of the international criminal law, and followed by Rome Statute. The Rome Statute 1998 has been created. It developed further international criminal court for the prosecution of the international crimes. There are four important international crimes which is prosecuted under the International Criminal Court. That is genocide as per the Article 6, Article 7 about a crime against humanity, Article 8 is about war crimes, Article 8A which is about the crime of aggression. See, the International Criminal Court has a jurisdiction of these four crimes which is specified in the Article 5 of the Rome Statute. So these are the general outline which talks about international criminal law. So we'll try to see one by one articles about what are all the international crimes, what does it mean section. See, we will see Article 6 of genocide. The definition actually, which is taken from the Article 2 of the Genocide Convention, which is been directly specified in the Article 6 of the Rome Statute. Any intentional destruction of any member of the protected member belonging to the nationality, ethnic, race, or religious group, or killed, or intention to kill, or the transfer of children, or preventing the birth or public inflictment of these people are considered to be a genocide. The crime uh, against humanity, which includes the widespread systematic attack of the murder or extermination or deportation or the torture, imprisonment, or enforced prostitution or persecution, or the forced disappearance or apartheid, which is all comes under the crime against humanity. The Article 8, which talks about war crimes. The war crimes basically it's a gross violation of humanitarian law, which includes the Geneva Convention on the Hague Convention. It actually protects the civilians. The protects the civilians, and there are some guidelines which is given uh, how the war should be fought and what kind of activities should be conducted during the war time. And of course, the crime of aggression means the planning, preparation, and like execution of the act of aggression by the person or the position effective of control or direct political military actions of the state, which includes invasion, attack by armed forces, or sending armed groups or mercenaries. So now we have seen overall outline of international criminal law, right from the definitions or nature of crimes or the important principles or sources of international criminal law. And we have touched upon the Rome Statute, like International Criminal Court can be prosecuted about the international criminal law. So we will see the next time about the different of in depth about international crimes. Okay, thank you very much for patient listening. I thankful to everyone for listening. Thank you very much.